everyone. It's noon now, actually. My name is Anju Anna John, and I work as a project officer with the Prison Reforms Program at Commonwealth Human Rights Initiative. Thank you all for your patience, and we'll be starting the meeting shortly. In the meantime, I would like to make some housekeeping announcements. As a general request, to avoid any interruptions, we would request that everyone switch off their videos and audios during the event if you're using the Microsoft Teams app. And towards the end, we would also be having an open discussion where we'll be welcoming questions and comments from the audience. So if you would like to contribute to the same, we would request you to click on the hand icon on top of your panel on Microsoft Teams app. And once you click on that option, the moderator will place the questions before the panel sequentially. To commence the event, I would like to request Mr. Sanjoy Hazarika, International Director, Commonwealth Human Rights Initiative, to deliver the welcome address.
Thank you, Anju, and welcome everybody to this opportunity. Sorry, may I request you to kindly mute your audio? Thank you. Justice Madan Lokur, former Justice of the Supreme Court and member of CHRI's Executive Committee. Justice S. Muralidhar, if I'm not mistaken, newly appointed Chief Justice of the Orissa High Court.
Not yet.
It's not yet, but anyway, the Justice of the Punjab and Haryana Court and Executive Chairman Punjab SLSA. We are very pleased to have Justice K.H. Nobin Singh, who is the Executive Chairman of the Manipur SLSA, Mr. Nasiruddin SL, Principal Jail Staff Training College in Ahmedabad, and Mr. Sumit Anand, who is the Secretary of New Delhi's DLSA. And we have also had pleasure in welcoming Mr. Bhimbedkar Pradhan, Secretary General of the NHRC, as well as representatives from the NLSA, SLSA, prison and correctional departments, other professionals, lawyers, and my own colleagues at CHRI to this release of our new report responding to the pandemic, prisons, and overcrowding. The Access to Justice program at CHRI, which includes prison and police reforms, which are easier said than done, is one of CHRI's oldest programs, or it is the oldest program. And we have been able to complete this study on time because of the great cooperation and support that we have received from SLSAs and the NLSA from across the country. And this has enabled the authors of this study, Sugandha Shankar Mathur and Anju Anna John. Anju was just introducing the program, to complete the work on time. They will, of course, be introducing and speaking on the report shortly. But like all efforts at CHI, this has been a team effort. I will speak briefly not about the report, but about the need for sustainability and the need to have, in a way, the stamina of the marathoner, or perhaps the half marathoner, on these difficult and urgent issues. We've seen the ruling of the Rajasthan High Court following a news report on the prevalence of caste in driving the work of the division of jail labor. The media and outreach are critical to impact on policy and practice so that these studies go beyond the launch and become embedded in cultural approaches as well as behavioral conduct and institutional change. These may be incremental steps, but they're all interconnected. It's like our world. We're all one world, but we are many systems and peoples. But without behavioral change on all sides, including stakeholders, of course, sustainable changes will not happen. The report records that after the setting up of what was called the high-powered committees by early in the pandemic across the different states, there was an average fall in prison occupancy rates in 22 states and union territories. They fell from 107.8% at the end of 2019 to 103% on the 1st of April 2020. And then again, by the end of June, they fell to 93%. A closer look may show that 27% of prisons in 19 states and union territories continue to be overcrowded. The point is here that despite the epidemic, or shall we say because of the epidemic, this was possible. In a crisis, this has become possible. So why not in normal times? We are not sure what the new normal is or will be, but perhaps this is a good sign of the new normal, that prisons are prisoners are released who've been staying there for well beyond their time. And this is especially so, and it can be a good practice, a best practice scenario which we can show to other countries, because India does have among the highest prison occupancies in the world, if not certainly in the Commonwealth. So our effort must be to devise strategies to ensure that every prison in the state has an occupancy within its sanctioned capacity, and the process of decongestion needs to be continuous. Uh, as you have seen from the report, those of you who've got it, we examine the functioning and efforts by the HPCs to decongest, but also analyze the work and the efforts of the UTRCs, the Undertrial Review Committees in 17 states and union territories. As we all know, the prisons have been considered, not just in India, but across the world, high risk areas for the spread of COVID-19 because of overcrowding, the lack of adequate healthcare facilities and resources. But it has shown, we have seen that through the response to the pandemic, the influence of the courts, the high-powered committees, that a coordinated response is possible, involving judicial officers, prison administrators, legal aid providers, and police and district functionary, along with, in collaboration with civil society groups. This has the potential not just to address systemic changes, but as also to bring about the changes that we seek. CHRI has called upon the Supreme Court to actively monitor these decongestion efforts, requesting the HPCs to conduct periodic reviews and also oversee the UTRC functioning. And I think that there is concern that states like Delhi, Union Territory like Delhi and Chandigarh, and states like Chhattisgarh and Uttarakhand, which have decided not to extend interim bail or parole, there is a fear of overcrowding, and that this is nearly not over. This fear is not over. We have a set of recommendations, and I will leave my colleagues to deal with this, but I'm very happy to welcome you to this event. And thank you all who took part in it, because all the SLSAs who are represented here and others who could not be here, the NSA, you are also co-authors with this, with us in this. We are all in this together. Thank you very much for your attention, and I'll hand it back to Anju. Thank you.
Thank you, Sanjoy, for that very positive welcome note. On that note, I would invite Justice Lokur, retired judge of the Supreme Court of India and also a member of our executive committee at CHRI, to kindly launch the report.
Yeah, thank you, Anju.
Yeah, I believe there's a small video or presentation. Yes.
Wonderful. Okay.
Sir, if I may, with your permission.
Yes, yes. Yes, please.
Thank you. Yes, so I'll quickly make a presentation where I'll deal with the findings of the report, and my colleague Sugandha would look at the key recommendations based on the report. Let me just share my screen. Yes. I hope this is visible to everyone.
Yes.
Yes.
Yeah,
Okay, go ahead.
Yeah. Okay. Before I start with the findings, let me quickly take you through the timeline of this report, timelines of the developments around decongestion of prisons. On 11th March 2020, the World Health Organization declared COVID-19 a pandemic. On 16th March 2020, the Supreme Court took suo moto cognizance in the case in writ petition in re Contagion of COVID-19 Virus in prisons. On 23rd March, it passed an order directing that every state set up a high-powered committee and also required Undertrial Review Committees in every district to function on a weekly basis. And by 1st April 2020, 22 states and union territories had already convened at least one HPC meeting. Now, because of that, we decided that to take the time period between 1st April and 30th June, which comes up to about exactly 13 weeks to do our study. And towards this, we requested information from both prison departments and the State Legal Services Authority. The prison departments were requested for information regarding prison-wise and month-wise data on release and admission of prisoners, prison population based on categories. These included under trials, convicts, and others, and prison population based on gender of prisoners, male, female, others, and also the number of temporary prisons set up in the state or union territory. For the SLSAs, we requested the minutes of the meetings of the HPC, the number of districts where UTRCs were set up, and district-wise number of UTRC meetings that were held, and the minutes of UTRC meetings from any 5 districts in the state. Additionally, we also requested for a para on the good practices adopted by jail visiting lawyers and paralegal volunteers towards effectuating releases. We received responses from 22 prison departments, 19 SLSAs, and 13 of these were from the same state. So in the sense, we got 13 responses from both prison departments and SLSAs of the state. Now, going on to the key findings, I will be dealing with firstly the decongestion effect, the effect of the decongestion efforts, and then move on to the functioning of the high-powered committee, where I'll look at their meetings, also the categories they identified for release and the categories they chose to exclude, and then the initial period of the release, and finally the functioning of the UTRC. Following this, my colleague would look at the key findings and key recommendations. Firstly, on the impact on prison population, we looked at the change in prison population between 1st April and 30th June for 22 states or union territories, and we saw that there was an average fall in prison population by 10.42%. However, in 8 states, which included Haryana, Kerala, Maharashtra, Manipur, Meghalaya, Mizoram, Nagaland, and Punjab, the fall in prison population was actually much higher than 10%. However, in Bihar, Jharkhand, Uttar Pradesh, and Andaman and Nicobar Islands, there was an actual increase in prison population during the same period. If we're looking at the occupancy rate in prisons during this time, for the 22 prisons that we looked at, according to PSI 2019 report, that is the Prison Statistics of India report of 2019, the occupancy rate on 31st December was 107.8%. This came down to 103.1% by 1st April, and by 30th June, it came down to 93.3%. Now, if we are looking more closely at the prison-wise occupancy instead of the national average, we see that 27% of the prisons where we received responses regarding the prison-wise data were continued to be overcrowded. And this was as of 30th June 2020. In some of the states, we received responses regarding the temporary prisons that were set up. And of these, 7 states and 1 union territory, that is Bihar, Goa, Kerala, Maharashtra, Manipur, Meghalaya, Uttarakhand, and Chhattisgarh had set up temporary prisons, Kerala having the highest with 55. On high-powered committees functioning, we received responses from 28 states in total, and of these, all of them had set up high-powered committees. On the basis of the responses we received regarding the minutes of the meetings, there was an average of 3 meetings that were held in by each HPC. There were 6 states where only 1 meeting was held. This was Himachal Pradesh, Meghalaya, Nagaland, Telangana, Tripura, and Sikkim. Odisha held the highest number of meetings with a maximum of 15 meetings between 1st April and 30th June. Now, we asked ourselves whether there was a correlation between the states which held the maximum number of meetings and the change in prison population. However, our data suggests that there was no such correlation. However, but where the prison HPCs held more meetings, they were able to monitor the functioning of the prison better and also direct actions regarding curbing of the spread of the virus better. On to the point regarding categories identified for release. These were the top 10 categories that were considered for under trials. The Supreme Court had suggested one category being those who were imprisoned for cases where the maximum punishment was for 7 years or less, and 23 of the 24 states we received minutes of had chosen this as their category for release. And the other significant categories worth mentioning here is that only 3 states had looked at comorbidities as a category for consideration, and only 5 states, which include Mizoram, Punjab, West Bengal, Delhi, and Jammu and Kashmir, looked at old age as a category for release. Now, if we are looking more closely for under trials with regard to the categories they decided to look, 7 states restricted themselves to the suggestion regarding the 7 years or less category that the Supreme Court had suggested, whereas for convicts, Goa and Andaman and Nicobar Islands looked at just this category. The highest number of categories were determined by Delhi, Punjab, and West Bengal for under trials, and Haryana, Delhi, Odisha, and Punjab for convicts. The top 5 categories which were excluded by the HPC for even being considered for release were those who were in prison for crimes against women, crimes against children, offences under the NDPS Act, those who were foreign nationals, and those who were in for offences under the UAPA Act. If we're looking at the initial period of release, it ranged between 4 weeks to 24 weeks for under trials, with Andhra Pradesh and Chhattisgarh choosing to initially release for only 4 weeks, and Uttarakhand for a period of 6 months, which was the highest. With regard to convicts, it was a minimum of 3 weeks for Odisha and Chhattisgarh, and the maximum was by Meghalaya and Mizoram, which chose to release some convicts permanently on remission of sentences. Now, to quickly go through the Undertrial Review Committees functioning. We found that Undertrial Review Committees were formed in only 231 of the 284 districts that we received responses from. This was for 17 states that we received responses. And although this came up to a total of 13 weeks, we looked at it as a minimum mandated meeting of 12 meetings during this period for each district. So the total mandated would have been 2,772 meetings, whereas only 2,053 meetings were held against this. Mizoram had the lowest compliance. They did not conduct any UTRC meetings throughout their state during this period. Chandigarh had the highest percentage compliance with 117%. Odisha and Jammu and Kashmir had followed behind by 108%. Now, we also looked more closely at the minutes of 21 UTRCs, where we found that only 9 out of these 21 looked at all the mandated 14 categories that were identified by the Supreme Court. Now over to Sugandha for the lessons learned and key recommendations. Sugandha?
Thank you, Anju. Can you please move on to the next slide?
Yeah.
Thanks. So I think the most important lesson that we learned while we were doing this study was that the process of decongestion must not be treated as a one-time exercise. We recommend that the HPCs must continue to monitor the prison-wise populations, prison occupancy rates, and also oversee the functioning of the UTRC functioning. That's our first recommendation. The second is that we realized that while many HPCs directed police officials and judicial officers to ensure strict compliance of the Supreme Court order in Arnesh Kumar versus State of Bihar judgment, but the HPCs by and large failed to control the inflow of persons in prisons. They managed to release prisoners, but they did not take into account the inflow of persons. So therefore, that also requires focus of the HPCs. The third is that we recommend that the Supreme Court must continue to monitor the functioning of the HPCs, and with impending readmission of prisoners to prison, it is extremely important that the court continues to oversee their situation. So we've seen that Supreme Court has been active in some other writ petitions, but in this one we see that they've not asked for periodic reports from states. So if that happens, that will definitely help at the state level. Our fourth recommendation is that, we all know that the pandemic drew attention to the inadequate health facilities inside prisons. And while it is important that efforts to decongest prisons continue, it is equally important to ensure that those who cannot be released have access to adequate health care. So, the Supreme Court had directed to prepare prison-wise response plans, readiness and response plans. So, on the same lines, we recommend that the prison-specific health care plans must also be developed in collaboration with medical experts. Our fifth recommendation is regarding having to ensure effective communication between lawyers and prisoners. The prison departments must ensure that where physical visits are restricted, alternative means of communication are made available. We've seen some good practices where the mobile phones have been used, or sometimes even video conferencing facilities have also been used for the communication with families. But for lawyers, this was found missing. So therefore, we urge the prison departments to also focus on the communication with lawyers. Next slide, Andrew. Thanks. We also believe that the state government must allocate additional funds on need basis for prisons in view of the pandemic. Tripura was the only state government which allocated an impressed fund to prisons during this time to meet with the requirement of the pandemic. So the prison department may also undertake a prison-wise assessment of staff vacancies and develop short-term and long-term plans to fill vacant posts through contractual or temporary hiring of staff. So in a lot of prisons, we've seen that overall there's 30% of vacancies in prison as per our PSI 2019, Prison Statistics India 2019. So that must also be taken care by the state governments. Now, the media reports have suggested that several prisoners were arrested for commission of crimes within a few weeks of their release. So this is because there is no proper reintegration plans that have been developed. So if the prison authorities, along with the Department of Social Justice and Empowerment, probation officers, welfare officers, and civil society representatives, if they can come together, and they must deliberate together to develop these reintegration plans that provide comprehensive services and assistance to released prisoners. Our eighth recommendation is regarding the proactive disclosure of information. Very few states have actually updated their websites, and we only see that Maharashtra Prison Department has been regularly, in fact on daily basis, they have been updating the information on their website, which is a great thing. And on certain basic aspects, on prison-wise occupancies, on the number of people who've been infected, and how many have recovered, and the communication facilities that are available with prisoners. So on basic aspects, some information needs to be proactively disclosed on the websites. Our next recommendation is broader. When we look at the while we did the study, we realized that the judiciary and other stakeholders must also consider alternatives to imprisonment when we are talking about easing overcrowding in prisons. So the focus should also come on the alternatives to imprisonment, like the implementation of Probation of Offenders Act, and that should help in easing further overcrowding. The judiciary and with the help of the concerned departments must also develop now recovery plans to regain the normal pace of work to mitigate the impact of the pandemic on judicial processes. And this could be done by strengthening shared information, by more use of ICT infrastructures among the functionaries. So we believe that if these are done in a coordinated manner, as we've seen that in these last 3 months, all the stakeholders in many states, they have come together and have worked well. So we hope that this continues and we're able to move towards prison reforms. Thank you. And I would just also like to thank our two organizations, Tata Trust and Azim Premji Philanthropic Initiatives, who helped us in this study, and their contribution is much appreciated. Thank you. Anju, back to you.
Anju, you're on silent, you're on mute.
Oh,
You're muted.
Thank you. Sorry. Yes, thank you.
Back on mute again.
You need to.
Yeah, I don't know what's happening, but I believe I'm audible now. Thank you, Sugandha. That brings us to the end of our presentation. Now I request Justice Lokur to kindly deliver the keynote address.
Yeah, thank you, Anju and Sugandha, and the entire CHRI team. You've done an excellent job. I've gone through both the volumes that you have prepared, and it's a fantastic study. And I think it will be a trendsetter for future studies of this nature. So congratulations for that. There are two things that I would like to look at when I'm talking about overcrowding in prisons, right? One of them is, and you have mentioned that also, is how to prevent the entry of prisoners. That is to say, how to reduce the inflow. Now, it's all right, we talk about bail and not jail. What does that actually mean? The question of bail comes at a much later stage when the matter comes to the court. But I think the responsibility starts with the investigating officer. He has to decide, whether it is absolutely necessary to have that person taken into custody. Is that person likely to tamper with the evidence, abscond and so on and so forth. The prosecution also has a responsibility, because the prosecution is the one that is going to come before the court and say that, this person should be remanded to judicial custody or should be remanded to police custody. The judge also has a responsibility that on the basis of the material, should I grant bail to this person or not? And this is where I believe the legal aid lawyer becomes very, very important, because he is the first person to be in contact with the accused person. It's a matter of common experience that, a legal aid lawyer is appointed just at that moment when a prisoner, when an accused is brought before the court. And the court says, all right, you are from the legal aid, why don't you just find out what is the problem? Now, in circumstances like that, it becomes very difficult for the legal aid lawyer to actually effectively represent the client. So it's a responsibility, I think, that is cast on everybody who is involved in that system to ensure that if a person has to be sent to judicial custody or police custody, it must be absolutely necessary. Not because I have the power to send somebody to judicial custody, I will do it. Or just because as an investigating officer, I think, this man deserves to be inside. So therefore, I'm going to say that, a remand should be ordered. And that is one aspect, the responsibility on all the stakeholders. The second, again, there is a mention about that, is of plea bargaining. Now, plea bargaining is more than, I think about almost 15 years old in India under the law. Not utilized. We carried out plea bargaining in Delhi about 10 years ago. It was very successful. But, it just kind of lost the momentum. So plea bargaining is an excellent way of ensuring that at least for these petty offenses, some of these, less than 7 years, which the Supreme Court had talked about, many of them can be disposed of through plea bargaining. So there will be no congestion in the courts, number one. And number two, people don't have to be arrested. Number three, the victim, people say, the victim has no say in the criminal justice system. In plea bargaining, the victim is actively involved. The victim and the lawyer of the victim is actively involved. So, there cannot be any criticism to this. So that is, another area that needs to be looked at. Third, compoundable offenses. Very often, even though the offense is compoundable, nobody applies their mind. You committed an offense, I'll take you to court. Why is it not possible to see whether the offense is compoundable or not? And then see if it's possible to compound it, let's compound it. Why do we have to, only think about unauthorized construction of a minor kind, non-payment of house tax, which is compoundable? What about other crimes under the IPC, under the local laws? They're also compoundable. Many of them are compoundable. So that is the third thing that I think can be utilized for ensuring that, people don't start going into jail. Fourth, again, you mentioned that, Probation of Offenders Act. I think in the report, probably you mentioned almost defunct Probation of Offenders Act. Yes, it is almost defunct because the provisions of the Probation of Offenders Act are not being utilized. A first-time offender, do you really have to put him inside? Is that first-time offender the kind of person who is going to, abscond or not be available and so on? Are we not looking at that? I mean, is it that the Probation of Offenders Act was enacted, just for the fun of it? No, it has some meaning. So let's look at these 4 areas, I think, which can, reduce the inflow of persons coming to prisons. Now, once a person is in prison, how do we look at taking that person out of the prison? You have UTR committees, Undertrial Review Committees. If I remember correctly, in the 1482 prisons case, 1382 prisons case, it was directed that initially there should be a meeting every month, right? But now today, I'm surprised to find that out of 284 responses or something, Undertrial Review Committees have been set up only in 231 districts. There are 700 districts in the country. Why have they not been set up in the other districts? We need to ask that question. Because they are the persons, the local, district judge, the local superintendent of police, the local prison official, the head of prison in that district. They are the ones who are supposed to meet and decide and see what is to be done. And unless they take their job seriously, you're going to have people over there. And having a large number of meetings, like we found in Orissa in your presentation, is not going to help. Those meetings have to be effective, where discussions have to take place. So it has to be a district-wise thing, and one of the good practices mentioned in the report is that some of the HPCs have said, well, you confine yourself to your particular district. They're supposed to confine themselves to their districts. There have to be SOPs. NALSA had prepared SOPs for the functioning of Undertrial Review Committees. No SOPs for high-powered committees. So you can have a large number of meetings, you can have no meetings. What are you going to discuss in those meetings? How are you going to categorize? How are you going to decide that this person should be released, this person should not be released? So unless, the whole thing is put into a sort of a system, MHA has issued guidelines, but that is for the management of prisons, not for management of HPC functioning, not for, management of Undertrial Review Committee functioning. So this is something that has to be looked at. Number 1. Number 2, better software. We have good software, but it can definitely be improved. It doesn't take long to devise a good software which says that a person, this is on any given day, this is the amount of remission that the person has earned. Or this is the amount of time that the person has spent. And under the CRPC, if that person has spent 2/3 of the time or half the time, that person is entitled to be considered for release. The computer can tell you that in half a minute. And you don't even have to ask the computer. The computer can give you a prompt. You open the computer, it will tell you that these are the persons who have to be released today. So software management, and India is a powerhouse in software development. Why can't we take advantage of that? Third, open prisons and open jails. Some of the responses you have got, CHRI got, were from open prisons. How effective are they? I don't know. Perhaps open prisons cannot be overcrowded by the very nature of being open prisons. I have no idea. But I have visited some open prisons in Himachal, for example, in Rajasthan, working wonderfully. There is no question of any overcrowding. So let's look at something different, and there are several open prisons, but we don't know how they are functioning and what can be done to improve their functioning. So this is with regard to reducing the population in collaboration with UTR, Undertrial Review Committees, and high-powered committees. COVID management, very, very shocking. I remember reading in the report that something like 18,000 people were tested positive. I think I'm right about the figure. I also remember reading in the report that there are more than 4 lakh persons in custody. I took an average, 18,000 tested positive, 4 lakh prisoners. That works out to 4.5% of the population. Now, if you look at 4.5% of India's population, you're looking at 50 million people who are, COVID positive. Today, we have reached 10 million. That means in the prisons, the number of prisoners who have tested COVID positive are 5 times or 4 times, 4.5 times the national average. So that's a very, very large number. If in the country there are 1%, in the prisons it is 4.5%. That is, I think, a little shocking. So therefore, there appears to be some problem in this COVID management. How can that improve? What are the good practices that some of these states have, prisons have utilized? Sharing of information. A person should know that he has got COVID, and the other prisoner should know that he has got COVID. Family should know. The person is wanting to know whether his family is COVID positive or not. What is the difficulty in making arrangements for communication? Tihar jail had tried out an experiment, which I think at that time was successful. I don't know if it's continuing today, of allowing telephone calls. And they're monitored. So you make a telephone call to a particular number that is monitored. Communication with the lawyers, legal aid counsel, with the paralegal volunteers, missing. So a person, first of all, if he is not well, he is not granted, release by the high-powered committee because there are no SOPs. So persons with, comorbidities, persons with other ailments, persons who are senior citizens, pregnant women, not being granted bail, or not being granted parole, or not being granted release, whichever way you look at it. Why? Because, and this opens up the debate that has been going on for a long time. It was settled, in my view, when the Supreme Court gave the judgment in Bachan Singh's case, I think 1985 or 84, they said that you have to look at the crime and the criminal. Don't look only at the crime and say that, because this person has committed this crime, therefore he will not be released. But supposing that person is sick, supposing that person is on his deathbed, you will say, oh, no, it doesn't matter. You can die in the prison. Why? Because you have committed a very serious crime. I am not going to release you. That cannot be the attitude. That should not be the attitude. Because then, during the time of COVID, you're getting unexpected results. You don't know who is unwell. You don't know how that person contracted, COVID. You don't know whether that person has got symptoms or is asymptomatic. So the whole thing has to be looked at, in a holistic manner, not just, segregated that, because you are UAPA, because you are crime against women, therefore, whatever your condition, I am not going to release you. It can't be like that. Some of the good practices that have been followed, and I think it should be, spread in different parts of the country, is, of course, the management of the Undertrial Review Committees confined to the district level. Digital communication, video conferencing, why can it not be used? Every jail in the country was given a video conferencing unit by the E-Committee. Every court in the country has video conferencing facilities. Why can't that be used? To find out. Jail visitors. I can understand when there was a lockdown, there were no jail visitors. But now, with social distancing norms which are being practiced in many of the jails, as per the report, it can be done. Use of masks, does not seem to have been, encouraged in a big way. Whatever the reason, I don't know. But yes, it is one of the ways of, reducing the possibility of getting COVID. Personal monitoring by the executive chairman in some states. Others can also do it. Many judges are not attending court on a daily basis from 10:30 to 4 or from 10 to 4 or whatever the court timings are, because physically it is not possible. And there are difficulties in holding court through video conferencing. They can be involved. It doesn't have to be only the executive chairman of the State Legal Services Committee. It can be any judge. So I think these are areas which need to be looked at. We are facing strange times. We are facing COVID problems. But we have to find solutions. There is no point in saying that okay, this thing has come down to 93%, so very good. It will go up. Fortunately, COVID will also get defeated sometime or the other. But then when it starts going up, then what do you do? So let's look at it, in a far broader perspective. And a large number of ideas have come through the reports, both the volumes. And I think let's look at it, in a more humane manner, involving just about everybody: the judiciary, the police, the prison staff, civil society, prosecution, legal aid, and try and see how we can improve the situation. We've been talking about prison reforms, I think, from the time of, Mullah Committee, from the time of Sunil Batra. Sunil Batra was 40 years ago. So I think it's now time, when we started doing something, rather than, just, looking at a problem as and when a crisis occurs. Supposing if a crisis does not occur, and I hope it does not, we should not be caught off the back foot. Thank you very much, and all the best to all of you.
Thank you, Justice Lokur, for those very insightful suggestions on practically addressing the situation of overcrowding in prisons in a more permanent way. Now, I would like to request all the panelists to switch on their videos, just the panelists, and keep their mics off. I would be moderating the session on decongestion of prisons, next steps. I'm pleased to introduce the esteemed panelists who have agreed to contribute to our discussion today. The pandemic has demonstrated that coordinated efforts could result in effectively addressing the issue of overcrowding in prisons. We hope that this discussion will reflect on the challenges faced in the implementation of the Supreme Court directions, good practices that emerged during the process of decongestion, lessons learned, and what the speakers envisage as the role of the high-powered committees and the state-level functionaries in the near future. We have two chairpersons of the high-powered committees of Punjab and Manipur, a principal of the jail staff training school in Ahmedabad, and a DLSA secretary. Justice Muralidhar, who would be the first speaker, is the executive chairperson of the Punjab SLSA and therefore also the chairperson of the high-powered committee there. And although he's presently a judge at the High Court of Punjab and Haryana, he was earlier practicing and is known for his pro bono work, which included the case of the victims of the Bhopal gas disaster. And in 2006, he was appointed a judge in the Delhi High Court. And at this point, I would also like to include the fact that I was working with him for a short period between 2016 and 2017. Yes, Justice Muralidhar, if you could share your views on this.
Thank you, Anju. Justice Lokur, Justice Nobin Singh, the entire, Mr. Hazarika, the entire team of CHRI. I must join Justice Lokur in complimenting Anju and Sugandha in putting together a remarkable report with such detailed analysis, just marshalling, so many facts from so many jail authorities and state legal services authorities must have been a Herculean task. And you've managed to somehow achieve it and make an eminently readable report with very, very useful suggestions. I would want to begin by picking up two of the important aspects that you have mentioned. One is about the medical facilities in jails. What has happened in Punjab is we've had to evacuate certain jails to create COVID care facilities for prisoners. So we have special COVID kind of facilities. So 2 or 3 prisons and even some sub-jails have had to be evacuated and for taking care of prisoners who test positive. So this is definitely one aspect of the report, I think, which needs urgent attention. We should not be talking only of medical facilities in COVID times, but even in non-COVID times. Very often we are having to, order on the judicial side, transfer of prisoners from one jail to a jail next to, an available, a better medical facility. And this is one aspect that requires to be very carefully looked into by all states and prison administrations everywhere. So this is, I think, an important, recommendation, the need for upgradation of medical facilities. The second is about the improvement of the video conferencing facilities. Just to pick up where Justice Lokur left off, while it is true that every prison in the country and every court has a video conferencing facility, the quality of video conferencing is not uniform. So while you may have in some courts, some of the even district courts, state-of-the-art video conferencing facilities, and like your report points out, in many prisons, the video conferencing facility has not been upgraded. So the bandwidth has not improved, and the links are not so good as we would like them to be. And although your report does mention that funds have been allocated for this purpose, I don't know what the bureaucratic hurdle has been in reaching these funds to the prison administration in different states. And this is another aspect which requires very urgent attention, that the quality of video conferencing facility must be improved. But I have a caveat to add to this. And I've said it earlier as well. While video conferencing is useful as a temporary measure which avoids unnecessary transportation of the prisoner to the court and back, the prisoner is not able to very frankly tell either the court, which is passing a remand order, or even the lawyer who's at the other end of any problem the prisoner may be facing. So there is a certain element of privacy in the communication between lawyer and prisoner, which needs to be preserved, some confidentiality which needs to be preserved. So while we talk of communication between lawyer and prisoner, we need to look at how this is done elsewhere. And is there, for instance, a glass, enclosure, which can be within the sight of the prison official, but definitely out of hearing of the prison official, where the prisoner can converse with the lawyer. And this is something that we need to look at. What is the state of the art as far as this is concerned? Because if this is going to be a norm, that we're increasingly going to have video remands and the use of video facilities to interact with prisoners, then this additional aspect of confidentiality in the communication between the lawyer and the prisoner has to be maintained, because that is one thing that the prisoner has the advantage of when he's produced physically in a court. Even when he's in the lockup in the court premises, he can talk to his relatives, and they can communicate. And sometimes when they're brought into the court also, they can tell lawyers, their own lawyers, things that they may not be able to tell in the presence of a prison official or any other police officer. So this is something that I thought I would like to dwell upon. The other thing I find is many prisons, although there are, jail visiting legal aid lawyers on the panel of the legal services committees, they're not able to furnish the prisoner with the complete information on the prisoner's case. And that's understandable, because the lawyer visiting the jail may not be the lawyer handling the case. So in Delhi, we started this experiment, and which needs to be carried to its logical end, of having a portal where the prisoner can go and access his case records. So basically what you do is you digitize the case record as a legal services authority. And because the legal services authority is handling that prisoner's case, and on a password basis or an exclusive basis, it's only the prisoner who can access his own case. He can't access somebody else's case. So it can be done even under the supervision of the prison staff. But if there can be a facility in each prison where the prisoner on a request basis can, go and access the copy of his own case record. That will go a long way into, remedying this one demand that most prisoners make of not knowing what has been filed in their case, what is the fate of their applications, and, which is the next date of hearing. So in the Tihar jails, we had the system of kiosks. But we found that, if there were 10 kiosks, some 5 would work well, 5 will not work well. And even those that work are not fully connected. So when we do provide facilities within jails in terms of, computers or kiosks, which have to be connected to the net, we don't make sure that this is state of the art. We don't make sure that these are functioning well. So it is one thing to provide a facility, the other to make sure that it works well. So this second part is something they're lacking. It's even true of courts, not just prisons. It's true equally of courts, that we need a constant upgradation, maintenance, because these are these technologies keep changing. They need constant upgradation. They need constant maintenance. So this is one aspect I thought we should be focusing on. I just have a few suggestions to make, and I think the CHRI wanted to know how come Punjab has taken the lead in releasing NDPS convicts, where many other states don't seem to have. I think the reason is obvious. We do have a large contingent of NDPS convicts and under trials in Punjab for various reasons, which are already there in the public domain. But again, there we've categorized this, cases where the sentence is 7 years and less, or the quantities are not commercial quantities. And we've categorized further, therefore subcategorized prisoners. And we've also looked at the need for NDPS prisoners who may be first-time offenders or, with not too many cases, having to also get some kind of a rehabilitation with their own families. Because, there is a disconnect between an NDPS convict and his family, because they're already, persons who are, looked down upon in their community and society. So there is a need to reintegrate. So I think these are this is the thinking that went behind in having an approach that does not exclude NDPS convicts from those who should be given the benefit of COVID-related release. And in Punjab, although the High Power Committee met again in November, and we were looking at calling back prisoners, we have kept that decision in abeyance because there is still a surge of cases in Punjab. I must share this with you, and this is one aspect perhaps Anju and Sugandha will want to look into. Most prisons depend on convicts for running the prisons, because prisons are notoriously understaffed. And this is from the pre-independence times, from the British times. We've always had convicts, and they're in fact called Munshi Qaidis. The convicts actually undertake many tasks within the prisons, including supervisory tasks. So, and this is an open, it's known to everyone, and there's no prison official who's going to deny this. And there was a serious move to call back convicts who had been released, given parole due to COVID, to call them back because there has been an inflow of prisoners even during the COVID times, as your report rightly points out. And there is therefore a need for having staff to manage the population that has remained in the prisons. So there is, I find in Punjab and perhaps in other states too, prison, the staff there is a need to fill up posts. There are a large number of vacancies in the prison staff. And this is going to be a problem that will continue to will continue to stare at us unless we do something on an urgent basis on filling up these vacancies in the prison staff. The third issue I wanted to highlight, which is connected to the convicts being part of the prison administration, is the wages of prisoners. What has happened as a result of the release of prisoners is that the wages they earn for the work they do in prisons, that probably has dropped. So that is another aspect in your report which you may want to reflect on, the link between prisoners' wages and the tasks that they perform in the prisons and what COVID does to that earning of the prisoner. Because we must remember that the prisoner's family it could be the wife, it could be the children, who are not supposed to be punished and who are not undergoing any sentence. They do depend to a certain extent on the earnings of the prisoner in the prison. So this is another aspect I thought I would like to highlight, which is also linked to what the COVID has done. I see the broad suggestion being this institutionalizing this oversight mechanism itself, like having these high-powered committees as a permanent aspect of oversight of prisons. And I would welcome that suggestion. From Punjab's own experience, having a senior judge, usually the chairperson of a legal services authority at the state level, would be the judge senior most next to the Chief Justice. And having a judge at that seniority oversee this, chair the committee and oversee this, prison administration and of prisoners and their facilities is a useful mechanism which can be institutionalized, and I would welcome that suggestion. So I hope I haven't exceeded my time. I again wish to congratulate CHRI for bringing out an excellent report. Whenever you release this report, Anju and Sugandha, you might want to think whether the further updated figures up to 31st December can somehow be incorporated into this report, because these figures are valid till 30th June. And I'm sure much progress has been made between 30th June and 31st December. But congratulations to both of you. And thank you for this opportunity for sharing my idea, the thoughts.
Thank you, Justice Muralidhar, for those very insightful comments and practical suggestions. But if we were to do the project or like the report again, we probably take another 5 months before we are able to release the next one, by which time it might become redundant again. So now, before I carry on with the panel discussion, I would like to inform the audience that we will be taking questions from the participants. You could use the chat box on either Microsoft Teams or YouTube to drop your query, and we will be taking a few to be answered by the panelists at the end of this during the open discussion. I would request everyone to post this before 1:15. I would like to now welcome our next speaker, Justice Nobin Singh, who is the Executive Chairperson of the Manipur SLSA. Justice Singh was a practicing lawyer who was appointed as Additional Advocate General for the state of Manipur and continued to hold the post till November 2014, when he was elevated as the judge of the High Court of Manipur. And he's presently the Executive Chairperson of the Manipur SLSA, which makes him also the Chairperson of the High Power Committee of Manipur. Over to you, Justice Singh.
Thank you. Honorable Sir, Sri Madan B. Lokur, former Judge, Supreme Court of India, my esteemed brother, S. Muralidhar, Honorable Judge, Punjab High Court, Sri Sanjay Hazarika, Director, CHRI, ladies and gentlemen. After seeing your report, not in detail, some of the suggestions which I have given are very important, relevant. I'll go through it and take note of that, and if possible, I'll share with the government so that the same can be implemented so far as the Manipur is concerned. And my esteemed brother Molina also has spoken on various aspects. On some of the aspects which are relevant, I'll share my views on that. But before I do that, I would like to share some information about Manipur, because circumstances from state to state differ. So far, my state of Manipur is concerned. It being a small state, we don't have much problem. There are two jails in Manipur. One is Manipur Central Jail, Sajiwa. Another is Manipur Central Jail, Imphal. The first one is meant for the male prisoners, while the other is meant mainly for the female prisoners. As per information furnished by the jail authority, the first one has a capacity of 845 prisoners, out of which 586 are there at present. And in respect of the second jail, it has a capacity of 250, out of which only 34 prisoners are there at present. This is the scenario in Manipur. Now, the High Power Committee, in its first meeting held on 31st March 2000, we considered the aspect. But since the additional DGP prison informed the committee that there was no congestion in the jail and all possible measures being taken to prevent the spread of COVID-19 pandemic in both the jails. No recommendation was made for the release of prisoner. But we laid down certain guidelines on that day. First one is the prisoner inside the jail are to be screened for the symptoms typical of flu, fever, etc. This is the first condition. Second, no new prisoner will be introduced in the jail without medical screening. Third, all the new prisoners are to be kept in the isolation wing for 14 days, and only when they are confirmed that they are well, they will be transferred to other sections. Fourth, in case of suspected cases, the prisoners will be taken to government quarantine centers and be kept under proper security. It was further resolved by the committee that the Home Department shall take up necessary steps to temporarily designate or notify certain places as quarantine prisons to avoid overcrowding and congestion in the jail. Pursuant to this recommendation by the committee, state government declare a particular area, which is an academy or academic training center, I think probably, has been declared as prison quarantine prison. Further, we directed the DGP to issue necessary instructions to the police personnel to strictly comply with the provisions of CRPC at the time of arrest and detention and the health advisories before the protection of the accused before the court / magistrate. Thereafter, the concerned magistrate / judges were requested to ensure that the accused produced before them will be medically screened for COVID-19 before they are sent to judicial custody or the above said quarantine prisons, as the case may be. These are the conditions which are given by the committee general one. Then at the time of release of the prisoner on bail or on parole also, we put certain conditions. Let me read 1 or 2 conditions here. First condition is under no circumstances a prisoner will be released without proper medical screening and tests. And if the prisoner is to be released shows symptoms typical of flu, fever, etc., he or she will have to be kept in the quarantine. Under no circumstances a prisoner will be released without his consent. If any of the prisoners recommended for release by the committee has been languishing in the jail due to non-furnishing of surety bonds only, despite bail being granted by the regular court, he or she may also be released on his or her personal bond. Fourth one is, as the public curfew has been announced all over the state, the Home Department, in accordance with the jail authority, shall make the necessary arrangement for conveyance of the related prisoners to their residence. In view of the prevailing circumstances in the state, including curfews, lockdowns, the resolution of the High Court Committee shall be treated as bail application for the UTPs recommended by the ISPs. These are the conditions that have been laid down by the committee general and at the time when they are released on bail. Now, first aspect which my brother Mulir had talked about, there is health issue. So far the health issue is concerned, this committee, during its inspection on 16/9/2009, found that there were no proper medical facilities and equipments in the jails. Accordingly, the Manipur Legal Service Authority decided to extend its help by providing certain items like hospital beds, patient exam table, dustbins, water filter, medical officers table, chairs, the hand sanitizers, face masks, etc. In fact, these facilities were there, but it was not proper. So we provided this to the jail. And the second one is, when we visited the kitchen being used for the cooking of the food items, the LPG gas was not being used. Then we recommended to the government also, I mean the jail authorities, to introduce this LPG gas system for purpose of cooking so that the health hazard may not be there. This is related to the health issue. So far as the communication of the prisoner with his or her advocates. We have installed this facility for the video conferencing. Whether these facilities are sufficient or not, for which, as per the direction given by the E-Committee Supreme Court, we visited the jail and we identified the equipments requirements in that particular jail, and we placed our recommendation to the High Court for onward submission to the E-Committee on the Supreme Court. We have already requested the jail authorities to provide the communication with the advocate through this video conferencing. They have agreed, and by now they must have already started now. But one aspect which I would like to share with you is that the COVID-19 pandemic has compelled us to take optimum usage of technology wherever and whenever possible. In one of the meetings of the ISPC, an issue relating to collection of information data of the prisoners came up for consideration, as there was apparent lack of coordination between the jails and the courts, in the sense that there was mismatch of the data provided by the jails and the courts. In order to address the issue as a means of providing effective legal aid to the prisoners, the Prisoner Database Management Portal developed by the Manipur Legal Service Authority was launched on 15 October 2020 by the Chief Justice of the High Court. In fact, the development of the portal was commenced last year. It is similar to the ICJS insofar as it intends to provide linkage between the courts and the jails. But it is slightly different from the ICJS as it is developed from the perspective of providing effective legal aid to the prisoners. The records of the prisoners of both UTPs and convicts are digitized and uploaded in the Prisoner Database Management Portal. Only the authorized persons can check the details, including the particulars of the prisoners, FIR number, nature of the offenses, status of the trial, next date of hearing, etc., by logging in to the portal. The prisoners themselves, and in particular UTPs, can check the time spent in the custody, legal aid provided or require, if any, status of their cases, trial via a kiosk machine which is installed inside the jail premises with the help of jail staff and PLBs. And they can ask for other information as well related to their cases. The details of the members of the family who visit the jail will also be properly updated with the help of this portal. The Prisoner Database Management Portal is a fully web-based portal that can provide real-time data of the prisoners along with the requisite details of their cases to all the authorized persons. The striking feature of the portal is that the time spent in custody by the prisoner will also be available in real time. The portal intends to provide a much needed support system between the jails and the courts in the state. It will bring about ease of flow of communication while saving precious time and manpower. The legal aid clinics located at both the jails will be able to monitor the service surrender more effectively. These are the steps being taken by us through Manipur Legal Service Authority, and appropriate steps being taken by the ISPC from time to time as per the information furnished by the jail authorities. This is what I feel so far Manipur is concerned. Thank you very much.
Thank you, Justice Singh, for aptly summarizing all the efforts that are being taken by the Manipur High Power Committee. We now move on to our next speaker, who is Mr. Nasiruddin, who's also the principal of the Jail Staff Training School, Ahmedabad. He is a science graduate and also a holder of an MBA and an APCA Vellore alumnus, and is presently serving as principal at Jail Staff Training School. He's heading the project of transforming the JSTS to Gujarat Institute of Correctional Administration and a member of Gujarat Prison Manual Review Committee, a member of Committee for the Constitution of Gujarat Prison Development Board, and ex officio member of Prison Staff Welfare Board. Welcome, sir. Sir, you're on mute. Hello, sir. Are you there?
Anju, you might move to the next panelist if you.
Yes, I think I'll try unmuting him myself.
Separately. Thank you.
Yeah, okay. All right, okay. Yes. Moving on to our next speaker in the interest of time, Mr. Sumit Anand, who's the Secretary of the New Delhi SLSA. He's an officer of Judicial Services batch of 2013 and has discharged his duties as Metropolitan Magistrate at Karkaduma Court and Patiala House Court. And from September 2020, he has been appointed as full-time Secretary of the DLSA. First at the East District and presently at New Delhi. Welcome, sir.
Thank you very much. A very good afternoon to everyone. At the outset, I convey my regards to Honorable Mr. Justice Madan B. Lokur, former Judge Supreme Court of India, Honorable Mr. Justice Dr. S. Muralidhar, Judge Punjab and Haryana High Court, Honorable Mr. Justice K.H. Nobin Singh, Judge High Court of Manipur. Sirs, I was unable to wish you at the beginning as I was on mute from the far end. I also congratulate Shri Sanjay Hazarika, Director CHRI, and Ms. Anju and Ms. Sugandha and the entire team of CHRI on release of a meticulous report prepared by them pertaining to prisons and overcrowding, responding to the pandemic. As far as Delhi is concerned, in March 2020, against the capacity of 10,000 prison inmates in the 16 jails in Delhi, the capacity was around 16,000. In the past 10 months, around 5,000 inmates have been released from several jails throughout Delhi on interim bails as well as parole. However, the issue of overcrowding was still persistent, and the main reasons for this were that in February 2020, Delhi witnessed ethnic violence clashes, resulting in arrest of several persons starting from March and towards the beginning of April, and there was a significant inflow of inmates pertaining to these offences. Then there was an issue of repeat offenders. The offenders who were released on interim bails, considering the guidelines and the criteria laid down by the Honorable HPC, many of them were again arrested for committing various offences, and they were again brought back to the jails. And towards the later meetings, the HPC finally decided that any prisoner who violated the terms of the interim bail granted to him and involved in commission of similar offences again, then he would not be entitled to interim bails again under the same criteria. As the Secretary of District Legal Services Authority, it was our duty to implement the criteria and the recommendations laid down by the Honorable High Powered Committee in its letter and spirits. So the first issue that was faced by the District Legal Services Authority in implementing the criteria laid down by the Honorable HPC were the basic identification of the eligible prisoners who were entitled to be released. For that purpose, at the outset, legal aid councils were deputed in each jails. The secretaries personally visited the jails. There were constant meetings held with the jail superintendents, deputy superintendents, and assistant superintendents. Announcements were made on the public announcement systems, and subject to strict regards to the social distancing, the eligible persons who were eligible to be admitted to interim bail were permitted to visit the jail legal aid clinics. There was a segregation of custody warrants done by the jail staff as well as by the legal aid councils on the basis of the sections mentioned on the custody warrants. And on the basis of the sections mentioned in the custody warrants, it was identified that which category of inmates were entitled to be released on interim bail as per the criteria. Daily updates were taken by the secretaries of district legal services authorities from the legal aid councils deputed. It was ensured by the District Legal Services Authority that the same legal aid council visits the jail for a significant period of time, say for a week or at least 10 days, so that he can himself keep a track of the measures he had taken for identification of the prisoners who are eligible to be released. Then, whenever any letter or direct communication were received by the jail inmates by the secretaries of the District Legal Services Authority, quick and swift responses were given to them. All this time in the past 10 months, whatever we have been able to achieve in Delhi with respect to the decongestion of the jail, a very important responsibility was on the shoulders of the panel lawyers. During these times, the panel lawyers with their hard work have proved that advocates and lawyers are certainly the torch bearers of protection of rights of individuals guaranteed to them, especially the inmates, under the Constitution of India. Even in the thick of the pandemic, when the cases of coronavirus were on a rapid rise, the legal aid councils readily agreed and personally visited the jails. They had interactions with the jail staff, jail officers, as well as the inmates, and they often prepared the bail applications there in the jails itself before sending it to the court concerns. So the role played by the legal aid lawyers in all this effort of decongestion of the jails is certainly praiseworthy. A mechanism was adopted in Delhi for filing of the bail applications. Whenever a bail application was prepared by the Legal Aid Council in the jail premises, the same was to be verified by the jail superintendent concerned. And after the verification of the concerned sections, ensuring that a person is liable to be admitted to interim bail, and after his identification, the identification of his signatures and thumb impressions, those bail applications were received in the courts, especially in the office of the District Legal Services Authority, through a special messenger and a rider. And after verification of the same were assigned to the legal aid councils. On a routine basis, these applications were directly assigned to the remand advocates only, who were appointed in the courts for filing the applications as well as for pursuing the same. And before every UTRC meeting, which was convened weekly, the reports were taken from the legal aid councils about the fate of the bail applications which they had filed. With respect to the release orders, the learned Chief Metropolitan Magistrate Central District here in Delhi issued a circular wherein it was directed that the bail order itself, wherein the prisoner or the accused has been directed to be released on personal bond itself to the satisfaction of jail superintendent concerned, then that very bail order was to be considered as the release warrant. So in appropriate cases, instead of sending a separate release warrant to the jail concerned, the bail order itself was sent to the jail and it was considered as the release warrant. This led to saving of the significant time, and on immediate basis, the person would be released from the custody. And in any case, if there was any clarifications which were required, then on regular basis from the jail superintendent concerned, clarifications would come either directly to the court concerned or to the secretary legal aid, knowing the status of a particular bail application, and the same were responded promptly. Very recently, in a judgment titled as Sanjay Singh versus NCT of Delhi, a matter came before the Honorable High Court of Delhi on judicial side, where despite sending of release warrants, a person was not released from the custody for a couple of days. The answer given by the prison authorities was that there was some discrepancy in the release warrant pertaining to the sections or the names of the person. So therefore, as a precautionary measure, the person was not released. And taking note of the situation, directions were passed on the judicial side, and based on those directions, now a e-prison module is being prepared in Delhi, which will very soon come in force. And after the implementation of this e-prison module, there will be a real-time sharing of release warrants between the courts and the jails, and vice versa. And a nodal officer in each court will be appointed to remove any discrepancy in the release warrants which are sent to the court concerned. As far as the assistance provided to the prisoners released on interim bail is concerned, that as far as Delhi is concerned, the report in its volume 2, page 130, categorically records itself that safe transport was ensured to all such UTPs who were living outside Delhi. Coordinations were made by the jail staff, 3rd Battalion Delhi, with the SSPs concerned, so that all these prisoners can be safely commuted to their native places who were residing outside Delhi. Here I would like to add that not only safe transport was given, but some funds out of the jail fund and meals were also provided to the inmates released on interim bails. Now, if I say that no challenges were faced while decongestioning of the jails and implementing the guidelines laid down by the Honorable HPC, then it would not be true. There were several challenges faced because this is an unprecedented times and various unprecedented challenges came forth us. The first challenge that was faced by us was that the persons falling under the same criteria laid down by the Honorable HPC were not released on the same date. They were being released on different dates. And there were several reasons for this, that due to shortage of manpower, due to certain clarification required with respect to the sections with which a person is facing a trial, the record had to be seen. So they were not released on the same day. This resulted in restlessness amongst various inmates, that a particular person having the same charges has been released, then why he has not been released. Then prisoners and inmates failed to actually ascertain that they are in for different offences. For instance, a person inside the jail for a mere theft of a motorcycle compares himself with a person who is in for committing theft in a house. दोनों ये कहते हैं कि हम दोनों ही चोरी में बंद हैं. They simply say हम दोनों चोरी में बंद हैं. But they don't understand that the sections and the penalties involved are tremendously different and they do not fall under the criteria laid down by the HPC for release. This led to some dissatisfaction amongst the inmates. So to cater such a situation, the Delhi State Legal Services Authority started a project which was called as Project Pairvi. And in this project, often the District Legal Services Authority secretaries and the legal aid lawyers were sent to the jail concerned, where on the public announcement systems and otherwise individually also all those inmates who were becoming restless, they were told specifically about the criteria, that on what basis, what category of prisoners are being released. This resulted in some sort of satisfaction amongst them. And very recently, the Delhi State Legal Services Authority has come up with a project which is called Radio Chaupal. In this project, what we do is that any inmate can come to the jail common place, which is here in Delhi often called as Chakka, and there we have kept a register, and whatever query that particular inmate has, he can write it there or he can get it written by the jail staff. And once a week, either the secretary concerned personally goes to the jail or the legal aid lawyers who are on duty, they take up that register and give their views and opinions and answers to the questions put by the inmates. And what happens by addressing this on radio, the public address system of the jail, that on the basis of query raised by one person, all the inmates inside the jail get benefited, they get answer. And sometimes some of those who do not raise their questions, they also get answers to the questions raised. Then another challenge faced was extreme shortage of jail staff, and the convicts who work as sevadars were released on parole. So there was certainly a difficulty in categorizing the custody warrants of the jail inmates, which are usually managed by these sevadars only. Another issue which was faced by the District Legal Services Authorities was that inmates were ordered to be released on personal bond itself, only on the satisfaction of the jail superintendent concerned. But there were no specific guidelines or SOPs laid down for the satisfaction of the jail superintendent concerned. Most of the inmates, they were not having any ID proof with them or any person to identify them that where he is going to live. And unless those clarifications were taken from the court, finally, the person could not be released. Then finally, some good practices adopted here in Delhi for streamlining the decongestion process were that inmates were moved intra-jail within the same prison complex. The jails which were earlier specific for convicts were now also housing the under-trial prisoners. With the efforts of the Honorable Chairperson HPC here in Delhi, the residential flats adjacent to Mandoli Jail complex, having 12 towers, were converted into temporary jails which can house up to 4,800 prisoners. With the help of PWD, all the measures and SOPs of security were put in place in all these temporary jails. They are also being used as isolation cells. The guidelines laid down by Honorable Apex Court in the judgment of Arnesh Kumar versus State of Bihar are being diligently followed in all cases.
Hello. I believe we lost him. Maybe we can go to the next speaker at this point. Mr. Nasruddin, are you here?
Am I audible?
Yes, I can hear.
Yeah. I continue?
Yes, sir. Thank you.
Honorable Justice Madan B, sir, Justice Murlidhar, sir, Justice Nobin Singh, sir, Sanjay Hazarika ji, Ms. Anju, Ms. Sugandha, Ms. Madhurima, and all. It's a pleasure to be among you all. First of all, I would like to congratulate CHRI on release of this very meticulous report. It has been, I studied so thoroughly, and it has been so nice and kind of help as well to the prison officers to like understanding the things and understanding the reactions to the pandemic and what needs to be done and what we can do further. So I again thank you and congratulate you so much. I will start with the starting of the pandemic, like from the point of view of a prison officer. It was a totally different experience and it was a calamity, and we had to convert it into an opportunity, and ultimately it was a good learning experience for us. So I'll just give a brief of the journey that we as prison officers faced. In the initial stage, we had to prepare ourselves, and the very first step was to decongest the prisons. Because as we know that there has been a slight overcrowding in the prisons across India, and in Gujarat it's not that big, but still the prisons were overcrowded, and decongestion was highly required. So under the guidance of Honorable Supreme Court, HPC was formed here, and earlier there were 14,991, that is around 15,000 inmates inside the prison, and our capacity is of 13,724. With the help of this and under the guidance of HPC and following the recommendation, we released around 2,220 inmates in the very first round, and it led to undercrowding. It helped us getting space for this all isolation and quarantine and everything. So and by now we have released around 4,600 inmates, including those on parole and furlough. So the process of decongestion was, as described by my learned friend Sumit Anandji, it was like that and was a bit complex. We faced some challenges as well, but somehow we all were able to maintain it, and it helped much on the very initial stage. And decongestion of the prison was the very major step that was taken to prevent COVID inside the prison. As we know, it's a very close premises, and we were so worried, like once it gets in, it will be so tough for us to control, because you just can't go for that social distancing and 2 gaj ki doori and all in the prison, where we know that it's already overcrowded. And once, like people inside the prison are those who are already bit diverted from the general social or stream. So you just cannot convince them so easily ki bhai dur raho, don't go closer, don't shake your hands. They wear each other's clothes even. So it was so easy. So in the very first stage, we started making them understanding what is COVID, why it is necessary for us to take these steps. The awareness campaign was run, And earlier in the winter in Gujarat, we had this viral-free winter campaign as Dengai was here, and it helped us. It was a very base for us to make them understand what is virus and how we can control it. So, later inmates were also so cooperating, and we successfully managed it. Even and the panic was like on television. It was highly shown that surge in the cases and people are dying, hospitals are full, and we had stopped this mulakat system. So visiting was stopped. Now the thing was, inmates were so worried about their families, about their relatives, and everyone. Even people outside were much worried inside. And those who were able to contact their families on telephone, they did. Rest of the inmates, there were some very weak inmates, mentally weak inmates, who were so worried and they stopped eating. They started crying. So what we had to do is we had to contact the local police station. We asked them that go see their families, click their photographs, send it to us, and we showed them that they are okay. We showed them the videos, we showed them the photographs. So it was a kind of counseling for those who were so weak and were not able to accept the situation. Then we have to take care of their health. We have to keep them locked, and we have to take care of their human rights. That is our first duty. So like we gave them a motto in Gujarat that we are locked but not down. So they were locked and they were not down. We try to manage things, and we tried our best that they get their human rights. First thing was the rubaru visiting was stopped. So telephone calls were there. The frequency of telephone calls were increased. They were given video calling facilities with their home. We are having our own server in Gujarat, that is Jeevan system. It was started, that was used for only 4 central prisons, but then we started using it for all the prisons. And we tried to make them in touch with their families so that they don't get down. And it worked really nice. It worked so well. And one of the precautionary steps that we took, like shops were closed outside, and inside we are having canteens. So you just can't lock them, and you can stop the running canteen, and you just ask them to eat the prison food. So in advance, we recognize the things, the future, try to say it, and then we ordered things for upcoming 4-5 months. And we started e-money order facility. Post offices were closed. They were working for only pension cases. So we got in touch with the post offices, and we tried to start the e-money order facility. And we were the first in entire India to start this during lockdown with the help of post office and local administration. Even police supported it. Like those who are going for this e-money order facility, police won't stop them if they tell that they're going for the inmates and all. So we coordinated. Coordination was very important and it was the very first time like prisons started coordinating with various agencies like district administration, police, and legal authorities, DLSA, various NGOs. It was a time when we coordinated maximum with all. And when we released them, the major thing which learned friend Sumina also mentioned, that make them reaching their home was a big task. Like I was serving in Jamnagar as superintendent, and there was an inmate who was from Bhuj, Kutch, which is 500 kilometers away. There was an inmate from Surat whose place is 800 kilometers away. So then we had to plan it like we asked the police to give us the vehicles, buses and other vehicles. We arranged a tour plan, like a map, where we can cover the maximum destination in shortest route. And we sent them to their homes. We asked those people who were taking that home to take their photographs and assure the superintendent that they have reached their home safely. And even those who were local, we gave them food for 2 times. Those who were going outside the districts from each district prison, we gave them a food ration kit for a week. So, and incomes were stopped. Families, the earner was in, as Justice Muralidhar mentioned, that the wages were stopped. Now, even the prisons were in loss. Our industries were stopped, and those who were earning wages, they went out. They didn't have work, and they didn't have anything to earn. But still, they had to run their families. So, seeing this, we just try to give them as much as we can. And adaptation of technology was one of the factors which we learned, and constantly video conferences were conducted. Our respected Director General of Prisons, Dr. K.L.N. Rao, and DIG, Dr. S.K. Gadvi, continuously and constantly they conducted video conferencing, and there were around 60 video conferences during this pandemic. And they tried to be in touch with each superintendent. They used to aware us of each and everything, each SOP that is coming from the government, each decision that was taken by the HPC. And the use of technology helped us much in controlling the situations in the prisons. And rather than just being reliable on others, like we ourselves started preparing masks in Karnataka also, the Bangalore Central Prison, in Delhi, in Ahmedabad. The prisons started producing masks and PPE kits, and we helped other departments as well. So it was a kind of achievement for us. And things that were told by Honorable Justice Madan told about software. If we can have, as far as we are talking about decongestion, we should have a software. Now unification of prison system has been a problem. We are having e-prison, but it's a state subject and it's not that unified. So the rules for parole and furlough has been different in various states. So it has been a kind of problem. And prohibition cases here in Gujarat are not there in any other state. So again, including these things has been a problem in developing software. But still, e-prison is doing so well, and we are looking forward to improve the ICJS system. Health was a problem. What we did, we trained our staff on WHO courses, which were online. We trained our medical staffs from the prison, and then they started treating them. So we try to improve the health. We try to improve the hospital. And as we know, there has been recommendations since very long. You take Mullah Committee 1980-81, and since then there has been committees which have recommended the recruitment of staff, the recruitment of medical staff, the recruitment of uniform staff, the improvement in the health facilities, and improvement in the infrastructure of the prison. But those things are not adopted so far, but we are looking forward that the governments will look into it, and we as officers and bureaucracy will try to implement things as much as we can. So this is from my side, and I again thank you, CHRI, for preparing such a report, which has been a kind of help and which will be a good thing for us to refer while taking the next steps. Thank you very much.
Thank you, sir. Those were really insightful, practical observations from the ground from both you and Mr. Sumit Anand. I'm sorry you got disconnected in between. I hope that was all that was there in your speech. Is there anything else you would like to add on, sir?
That was all. Thank you.
All right. Thank you. Now we are moving to the open discussion session of our event. So if there is anyone who would would like to raise any comments or observations, you could raise your hand with the Microsoft Teams option there on the top panel, and then we could take your names in a sequential manner. Yes, Mr. Henry Tiffane. Oh, wait.
Can you hear me?
Yes, sir, yes.
Let me congratulate you, Anju, and all the team members for this wonderful work.
Thank you, sir.
As people who are on a daily basis concerned about issues related to prisons in our part of the world, we find that your contribution, together with all the other state legal services authorities and the jails in the other states, makes a lot of meaning. I feel very ashamed that the state that I belong to has been one which is Tamil Nadu, of course, has not chosen to respect this national process of such great value. I am definitely going to take it up with our DGP, Mr. Tripathi himself, and with the additional DG prisons, and tell them how much the people of this state and the prisons of this state have lost not being part of this process. Being part of this process is learning from Manipur, learning from the different states, Haryana, Chandigarh, from the other states who are here, and who have, and Gujarat and states of that sort. That was one. The question really was to find out, Anju, whether CHRI contemplates presenting these results and the findings and the recommendations to the Supreme Court? Do you plan to do an intervention before the Supreme Court? Because these now need much of what was said by Justice Madan Lokur and Justice Muralidharan. I took extensive notes of what they had to say. Excellent people that you had brought in here. But what they say now have to also be incorporated as part of judgments of the Supreme Court. So do you plan to do that? Recently, you would have seen we did an intervention on CCTV cameras, and the CCTV camera judgment also applies to prisons. And therefore, it will be good to see whether I wanted to know whether you are planning an intervention of this sort, even with the results of the 2 months of April to June, not wanting to extend it as somebody said till December. And I heard your reply also, Anju. But to see with what is there, if it goes to the Supreme Court, there are chances that we get good directions, and this entire gamut of people who are here would then be contributing to enhancing prison justice system in the country. It will be their contribution which the Supreme Court would then be able to give us directions. So the ball is in your court. We are willing to sail with you in the Supreme Court if there is a need, but I don't think there is a need because you people are on your own very, very strong. But I think it is necessary, and that is the point I wanted to make. Thank you. And congratulations to all the prison officials who are here, the senior officers who are here, the senior judges who are here from the State Legal Services Authority. Is amazing the cooperative hand that all of you extended to a powerful civil society voice of this country, CHRI. Thank you.
Thank you, sir. I believe Madhurima from our, who's the head of the prisons team, might be better equipped to answer that question.
Yes. Can I quickly just respond? Thank you very much for that comment, Henry. Yes, of course, that is part of the trajectory, is that, we would want to present this to the Supreme Court, and we are a part of a forum together with some other organizations. And it's not that we all need to be together. I think that is the biggest thing we all need to think about going forward, not only civil society, but I believe also the prison departments, the SLSAs, all of us. And this is what this decongestion exercise has actually taught. And I think this is what also the presentation made for Gujarat also highlighted, that it was the first time that, the authorities have worked together. So in a time of a crisis, they were all brought together. And I really hope that, this is going to go a little bit further as well. And, we'll be doing some positive things, can emanate out of this entire exercise. Thank you, Henry.
Thank you very much. Thank you very much.
We could take a couple of more questions or comments now. Yes, Ms. Shritu Kumar from HRLN.
Yes, thank you, Anju and Sugandha, for an excellent report. And it's really good to know what all the states have been doing, though we have also been following to some extent. And as part of the forum which Sugandha just mentioned, we have been trying to actually, we have been involved in some litigations as well with regard to the process where now, which has started, is that the released prisoners are being asked to surrender. And in many cases, that is becoming a problem because COVID is still very much present, and the situation in the jails is not any better. So our concern is that once now the process of surrender has started in many states, and if it goes on, it might bring the situation back to where it was, and in some cases even worse, like in Delhi, with the current number of persons in the jails, and if the released prisoners come back, it will become even worse. So I would like Justice Lokur and Justice Muralidhar, since they are here, if they have any suggestions on what their views are, whether they should be asked to surrender, or there should be any guidelines regarding that. So what would be the suggestions regarding that?
Yeah, okay. Can I take that?
Yes.
Yes, sir. Yes, sir.
Yeah. It may not be correct to have a sort of a blanket answer to this question. There could be some people who have been released and who have behaved themselves, behaved within inverted commas, who have behaved themselves well while they are outside. Can they not be considered for grant of parole? If there is nothing objectionable, they can perhaps be considered for grant of parole. There could be some who may have fallen sick while they were out. So I think each case will have to be taken up individually, and to say that because 200 people have been released, so therefore let's rearrest those 200 people and bring them back. I don't think that would be the correct answer to the situation. So that is one aspect. The second aspect is that those out of those, say, 200, there is a need to bring back, say, 100 or 150 or whatever number it is. They can always be checked, for the purposes of seeing whether they have, whether they are COVID plus or not. And if they're not COVID plus, and if it is necessary to bring them back, they can be brought back. So I think each case will have to be taken up on an individual basis. I'm not sure, whether the prison authorities or whether the police authorities are actually tracking, the persons who have been released. I just want to, share an experience that I had in Guwahati when I was there in 2010, 2011. A large number of people had been released on parole, including some, who had been convicted of murder and so on. And when we wanted to know, how many of them have actually surrendered, we found that a very large number had not surrendered. The parole period was over, and nobody, neither the police nor the prisons, took any initiative. And if I remember, at least about 64, 65 persons who had been convicted of murder had not reported back after being released on parole. Some of them, 2 or 3 of them, had died in the meanwhile. And they were on parole for about 6-7 years, because once they were given parole for 1 month, nobody bothered about them, and it continued like that for months together, years together. So really, there has to be this system of tracking in that sense, and individual case has to be looked at, and only then can a decision, or should a decision be taken, whether they should continue on release or whether they should be brought back to prison. Yeah, I hope that answers your question.
Yes.
Thank you, sir. I don't see any other questions. Is there anyone else who wishes to raise any comments or questions at this point? Okay. In that case, Justice Lokur, I had a question. What is your considered view on, certain categories being excluded, like the blanket exclusion of certain crimes under an act, no matter what the, sentence term is or the crime itself is, or under the UAP or NDPS as such, yeah.
Yeah. You see, I had adverted to that in the first part. You see, like I said, in Bachan Singh's judgment delivered by the Supreme Court, 5-judge Constitution bench, they said that for the purposes of sentencing, you have to look at not only the crime but also the criminal. right? And then you decide what is the sentence that you want to give. Now, similarly, in a situation like this, it can't be said that, let's only look at the crime. It's a UAPA case, or it's an NDPS case, or it's a, whatever case. So therefore, this person will not be released, whatever happens. That would be contrary to what the Supreme Court has been guiding, since 1984 or 85, whatever that year was. So you have to look at both. Now, you have instances, all of us are aware of it, of persons who are more than 80 years old, right? Just because the allegation against them is, of a serious nature, UAPA, you can't say, because it's UAPA, we are not going to release you. It doesn't matter if you're sick. It doesn't matter if you're, on your deathbed. It doesn't matter if you, are suffering from all kinds of diseases. We are not going to release you. That's not, the right attitude to have. But at the same time, it can't be said that, listen, regardless of the crime, the person has to be released. So it has to be both. Look at the crime, look at the criminal, and then take a decision. Don't just look at the criminal, or don't just look at the crime and say, all right, 1 out of 2 is good enough. So, we are taking action. Then that, according to me, is not correct.
Thank you, sir. Thanks a lot for that response. Yes, Mr. Sadananda had something to state, is it? There was a comment in the box. Would you like to speak now? Or, yes, I also see Advocate Raja raising his hand. So, Advocate Raja, you could speak now.
Thank you so much, Anju and CHRI team, for organizing such a good program. And it's really eye-opening, and the report and everything is good. And thanks to Justice Madan P. Lokur and other senior judges. And I would like to flag up one issue, that the foreign prisoners who are languishing in the Indian prison, their family may wanted to know about the condition, the global pandemic, and how these people are keeping inside the prison. There is no communication point through the embassy or some other mode to contact or tell that your person in the prison are safe. So there should be some modality that at least the Indian prison department, in the sense every state should inform their respective embassy that these many prisoners from your state, your country are here, they are safe, or something like some information should be passed. That was my concern, because I was visiting one prison in Pudal, where an HIV/AIDS affected women prisoner was suffering very much, and she wanted to convey that she's alive and she wanted to come back. She was imprisoned for 10 years in an NDPS case. So these are the concerns that we are really wanted to look up and wanted to do something for these issues. Thank you.
Thank you, Mr. Raja. With that, I think we've come to the end of the session. I would now request the head of the Prison Reforms Program, Ms. Madhurima Dhanuka, to deliver the vote of thanks.
Thank you, Anju. Thank you, everyone, for being here and patiently being part of this exercise today. Indeed, I want to congratulate my colleagues, Anju and Sugandha, for having done this meticulous work. And first and foremost, I believe the report would not have been possible had it not been for the prison departments and the SLSs who shared the data with us. I think that is one of the biggest successes towards the preparation of the report, was that prison departments showed and SLSs have themselves shared this information, vital information with us, which has led to the preparation of this report. So thank you very much. And of course, the report would also not have been possible had it not been for Tata Trust and for the Azim Premji philanthropy. if they had not supported the preparation and the completion of this report. And not to say the least, of course, all the eminent guests today who have spared their time to be part of this panel, share their views, and provide such great insight. I often, I always say that, it's very important to understand what happens on the ground. And I'm really happy that we had representation from the prison officers as well as from the DLSAs, where, we could understand how and what efforts were made, because often they do not come out into the forefront. We only look at what is wrong in the system, but we often do not really realize that there are efforts also being put in. And it's a matter of prioritizing those efforts to be able to achieve something, which we are all together trying to achieve the same thing at the end of the day. So on that note, of course, a big thanks to everyone in my team at CHRI, as well as our director, and for all his support in this. And of course, our technical person, Mr. Ajit, who of course is at the forefront of all virtual conferences and meetings that we are organizing in these difficult times. So thank you very much. And on that note, I end the session. I look forward to hearing feedback on the report. Of course, as I had also typed in the chat box, we will share the report with all the SLSAs as well as the prison headquarters. If there are any factual errors or data inaccuracies reported in the report for your states, I would request that you may share those with us, so that in the printed version, which we will be coming out with in January, we can make those changes to ensure that we provide a sound and validated report to all of you, which, as has been already stated by many of our speakers, will be very vital in deciding the future course of action in terms of the readmission of the prisoners back, in terms of future efforts for overcrowding. And yeah, that's all. Thank you very much, everyone.
Thank you, Madhima. And thanks, everyone, for joining in. Good afternoon.
Thank you, and congratulations once again.
Thank you, sir.
Thank you very much.
Thank you all.
Your support is always much appreciated.
All the best.
And